Good afternoon and welcome. This is the Cobb County Board of Ethics meeting. This is a specially called meeting. First order of business is to identify and state that we do have a quorum. We have full attendance of the board members, and I'm very appreciative. If we could just start to my right with Cynthia, if you will just introduce yourself and the elected office that appointed you to the board.
My name is Cynthia Smith, and I was appointed by Sheriff Craig Owens.
I am Winter Wheeler. I was appointed by Chief Magistrate Judge Brandon Murphy.
And I'm Carlos Rodriguez. I'm the chairman of the board, appointed by Judge Kelly Wolk of Probate Court.
Tanya Bird, appointed by Cobb Tax Commissioner Carla Jackson.
Leilani Plendle, appointed by the Board of County Commissioners.
Ron Yonker, appointed by the State Court Clerk, Tanisha Phillips.
Larry Cernovitz, appointed by Solicitor General Makia Metzger.
Lynn Rainey, Board Counsel.
And recording secretary. So thank you, Lynn. Thank you, members of the board, for being here. We are in receipt of a complaint. This was filed in December of last year. This was filed against 3 members of the Cobb County Commissioners, the Board of Commissioners, Jerica Richardson, Monique Sheffield, and Lisa Cupid. I'd like to turn it over to Lynn Rainey, our secretary, to kind of introduce the pleadings and the procedure that we're going to follow today. In attendance, we do have Mr. Savage. So, Mr. Savage, sir, if you'll just kind of pay attention, this will be a little roadmap for the day, please. Thank you.
Okay. The purpose of this public meeting of the Cobb County Board of Ethics, which is being broadcast on TV 23, is to reconsider the dismissal of a complaint filed by Mr. Larry Savage against Cobb County Commissioners Lisa Cupid, Jerica Richardson, and Monique Sheffield for the reason of untimeliness. The Ethics Board is required to proceed strictly in accordance with the Cobb County Code of Ethics. We will follow the rules set out in the code and will take such action as is authorized and required by that code. The board asks that all persons attending this meeting treat this proceeding, the parties, the board, and all other persons present with dignity and respect. The Board of Ethics is comprised of 7 persons, each appointed by an independently elected official who are fellow citizens of Cobb County, are registered voters, and are not employees of the Cobb County government. They're not paid for their service on this board. They will be transparent, fair, and impartial to each of the parties and will perform their duties to the best of their abilities. The first step under the Code of Ethics when a complaint is filed, prior to any other review of the complaint, is to determine whether it is filed within 6 months of the date the alleged violation is said to have occurred. The code states, quote, "The Board of Ethics shall dismiss a complaint which is untimely filed," close quote. Mr. Savage, you've been notified in writing that your complaint is dismissed as being untimely filed. You have asked that the board reconsider the dismissal. The board members have received copies of everything you have filed and had the opportunity to individually review in the privacy of their own homes and offices. Mr. Savage, this is your opportunity to tell the Board of Ethics in person why your complaint should not be dismissed for untimeliness. The Ethics Board will not be hearing your testimony or testimony from your witnesses today or considering affidavits, documents, or materials not already filed with the clerk of the county commission and previously provided to the Ethics Board. The board will only be considering your filed written complaint and other correspondence you have sent, as well as your viewpoint on timeliness. Please understand, Mr. Rodriguez, the chairman of the board, has the responsibility to ensure this meeting proceeds in an orderly, civil, and respectful manner, and within the bounds of the Code of Ethics, so he must retain the discretion to limit or terminate your presentation should it stray from the matter subject to our jurisdiction. The board will hear first from you, Mr. Savage. The three named commissioners and the county attorney have declined the opportunity to be present and address the board. The board will then discuss the matter here in public and vote. If a majority of the board determines that your complaint should not be dismissed for untimeliness, it must then determine whether there are any technical deficiencies, and if so, identify them and provide you an opportunity to cure them. Should they be cured, a date will be set for an investigatory review to determine whether specific substantiated evidence from a credible source or sources exists to support a reasonable belief that there's been a violation of the Code of Ethics. Should the board rule at the investigatory review that it does exist, a public formal hearing will be set at a later date at which all parties will be allowed to testify under oath, present the sworn testimony of witnesses and evidence. If the board, after such a formal hearing, determines clear and convincing evidence shows any violation of the Code of Ethics, it may issue a censure or a reprimand of any of the three named commissioners. However, if a majority of the board affirms today that the complaint was not timely filed, the complaint will remain dismissed. Mr. Chairman, I yield the floor to you to preside over this meeting.
Great, thank you, Mr. Rainey. Right, so specifically on the issue of timeliness, Mr. Savage, you're asking the board to reconsider the decision to dismiss. If you'd like to take this opportunity, the podium here to my right, if you'd like to step up to it, turn that microphone on. And just know that anything that you have filed with the county clerk, we have received it, the board has received it. So we certainly appreciate the time in preparation of those materials. The board has considered it.
Yes, the materials that I submitted in the last several days have been filed with the county clerk. That's the last thing I've done. The fundamental issue here of timeliness has to do with the 6-month limit upon the occasion of the event that triggered the ethics complaint. And your interpretation initially was that the ethics complaint was started and ended on October 25th of 2022. And that's at a time when the Board of Commissioners enacted their home rule plan for redistricting or taking over reapportionment of the county commission districts. That certainly was, I would consider to be the beginning, but my view is it was the beginning of a long-term period of continuous violation because that subject remained in the air and in the courts for many months afterward. And if I take it purely to the time in courts, I think it's fair to assume that the Ethics Board would not undertake an ethics complaint while it's being litigated in the courts. And since part of my allegation was that the ethics code had been violated when the commissioners did not follow the law in their adoption of the home rule plan. And my previous experience of the board has been that a complaint based on whether they followed the law depends upon whether a court has adjudicated whether they have followed the law. And in this case, it took until late in 2024, actually, before the final hammer came down on that part of it. And if you take it to the point where the county believes they ended it, that would be August 27 of 24, when the county commission voted to adopt or revert to the redistricting plan that had been submitted by the General Assembly in the beginning. If I refer to it again, I'll call it Act 562. And that gets us from August 27th, I believe, gets us in a 6-month window anyway. But I contend further that it is still a continuing violation, and here's the basic story on that. All of this comes down to the text of the Constitution, Article 9, Section 2, Paragraph 1, Home Rule for Counties. And this is the home rule paragraph, or home rule section of the Constitution. It says, the governing authority of each county shall have legislative power to adopt clearly reasonable ordinances, resolutions, or regulations relating to the property affairs and local government, for which no provision has been made by general law and which is not consistent with this Constitution or any local law applicable thereto. Any local law shall remain in force and effect until amended or repealed. Now, what the Board of Commissioners did on October 25th of 22 is they amended Act 562. I have the actual resolution here if anybody would like to read through it. They amended Act 562, and that was what the ordinance said. As of today, the amendment to Act 562 that they enacted is still in effect. When they made their decision late in August to go back to the other map, they decided to go back to the other map. They declined, didn't overlook it, they declined amending the resolution from October 25th. It was brought up, but they would not do it. So, according to the Constitution, that resolution that they passed that started it all is still the law in Cobb County. Now, they may have officially converted back to the other map, but the language that they used in converting back to the other map was very carefully chosen, and you can call it denial or some kind of a plan B with this resolution, whereas, and all these things that are identified in here are still the law in Cobb County under the Constitution. And so the 6 months isn't going to start running until they repeal the resolution. Now, I can go through here a litany of all the things that have transpired since the beginning of this. We've got the initial suit was filed in December of 22. That one didn't fly. We had some technical problems. By March of 23, which if we started counting 6 months from October 25th, we'd still be in the 6-month window. But by March of 23, the suit that eventually went through the courts was filed. And that's what I mean. I don't think that you would have accepted a challenge to the ethics of it while it was being litigated. And that litigation continued. It went through until the final decision by Judge Harris, which was, whenever. Judge Harris decided on January 8th of 24. But in the meantime, on March 15th of 24, a new lawsuit was entered by Alicia Adams, who had intended to run for commission seat, but was turned down because she didn't live in the currently active at that time map for District 2. So she sued the Elections Board. She didn't sue the Board of Commissioners. She sued the Elections Board. That was decided July 24th of 24 by Judge Hill. In the meantime, the first court decision was appealed by the county to the state Supreme Court. It went directly to the Supreme Court because it was a constitutional issue. And the state Supreme Court on May the 9th of '24 ruled that they didn't want to answer the question, I guess, but they elected to not rule because some technical matter had not been done to their satisfaction. I can tell you what it is if you really. The court said, we conclude that although the Flomes had constitutional standing, they did not show any uncertainty as to their future conduct that warranted declaratory relief. And that goes back to a state law on declaratory judgments. And I can't begin to tell you what they were looking for there. Nobody I know can actually answer that question. Nevertheless, they reversed the lower court. And that put it back into the hands of under the plan of the home rule maps. So at that point in time, the Board of Elections had to decide what to do about the coming election. And they had no choice at that point but to go forward and hold elections with a map that was just about everybody agreed was wrong. And that got us through the primary season and a runoff of the primaries, and that's when Judge Hill ruled. She confirmed basically the ruling prior by Judge Harris that it was unconstitutional, and she determined at that point that the current elections were not going to work because they were done incorrectly with the wrong maps, and ordered new elections. And now we are in the middle of the new elections that are taking place for District 2 and District 4. And that, without reading a lot of very boring text here, that pretty much is the story. So if we, it depends upon when you want to start counting 6 months, but I don't think there's any circumstance that would say that this was an open and shut activity on October 25th. It was merely the starting point. And my firm belief is that the violation is it still continues because the resolution is still the law in Cobb County. That was the resolution of October 25th. So with that, if you have any questions.
You said that there was a ruling in Cobb Superior Court finding that the redistricting was unconstitutional, and
Yes.
that was in January of 2024.
That was by Judge Harris.
Okay.
But that's the one that was appealed. The county appealed it immediately and went to the Supreme Court. And quite frankly, the county was trying to run out the clock. They took advantage of every opportunity to delay it. The plaintiffs asked the Supreme Court to expedite a hearing to settle it before the elections. The county opposed that.
So without weighing into the policy, whether it was lawful or unlawful, you would agree that the first ruling by a court that the home rule map was unconstitutional was in January of 2024, right?
Yes,
And you'd agree, you knew about that,
yes,
right? And that was in public,
yes.
that that certainly could have alerted you of the need to file a complaint and make the same allegations that you made then, or that you have made in this complaint that we received in December of last year.
Not really. When I say it's in litigation, the county filed their appeal immediately on the ruling in January.
Sure.
And that kept it in play as litigation. At that point in time, I don't want to try to say something I can't pronounce, but supersedious was invoked, which basically freezes everything in place. And for that reason, we were stuck with the maps that were in place prior to the court's decision.
Sure, it maintains the effect of the home rule map, but it doesn't change the court's finding that it was unconstitutional.
Well, the issue is,
It
it's
doesn't
not settled
affirm
at
it.
that point.
It doesn't reverse it, right?
It did, yes, well, no, it doesn't. The court's ruling was it was unconstitutional, which would
Right.
then make the legislative map, the Act 562, the active maps. But the supersedious says you go back to where you were before the suit.
Sure. Right. It doesn't provide relief. The effect of the map maintains, but it doesn't change the ruling of the court, which is based on my understanding of your complaint and your allegation of this continuous course of there being violations, that as a board, we wouldn't be able to entertain a complaint of an ethics violation until there's a adjudication of illegality.
Well, I say that based upon my prior experience when I was told that a complaint that an official had not followed the law could not be made until it had been decided in a court of law that they had. Now, I don't really agree with that, but nonetheless, that's the understanding that I was under. And it had not been decided by the Supreme Court, and by the time the Supreme Court ruled, which didn't help anything, the Adams suit had already been filed.
Well, you would agree that there's nothing in the county code that says that there is a tolling allowing the extension of time to file a complaint if the basis for the allegation is in court proceedings, right?
I'm not aware of anything in the code that says that, but I have an idea that's where you would go with it. I can't imagine you'd be having this hearing at the same time that it's being heard in Superior Court.
I certainly can't weigh in on any hypotheticals, but the point being, the code, the text of the code, which is what this board is obligated to follow, doesn't toll or extend time for the filing of a complaint simply because the basis of the complaint is tied up in litigation.
Well, it was well, my primary assertion is not that. My primary assertion is that the violation continues because they still have not repealed the act or the resolution.
So it's a failure to act. It's a failure to repeal that is a violation of the ethics
Yes,
code
they
in your mind.
created a condition that is a violation, and it continues to be a violation.
I don't mean to monopolize the time and have my conversation with Mr. Savage. If anybody else has any questions or wants to jump in, please just feel free.
So to clarify, tacking on to where we just ended, the complaint is that they did not repeal.
It has not been repealed, that's correct.
That's the complaint, that they did not repeal.
Well,
And that's
no,
what's
the
still
complaint is that they did
happening.
what they did, and it is still in effect. The complaint is almost 3 years long now.
Okay. And the fact that they did not repeal it is what you're saying, and that's
Yes.
what's still in effect and why we'll.
You know, if I'd filed a complaint immediately after they enacted the resolution, that's not going to go anywhere because nobody knows. I mean, to that point in time, their allegation was that they are the law constitutionally because they acted under home rule. And until that was fully litigated, how can you argue with that? And if I took an opening in a window between court opinions to file a complaint, I don't, in all honesty, I don't know if that'd be fair to anybody.
Well, I guess that's the trouble with operating under the provision in the code that no officer shall act in violation of the law, engage in any activity or transaction that's prohibited by law, is that had you filed it within 6 months of the act of enacting the home rule resolution on October 25th, 2022, you'd be debating with the county commissioners about the legality of it, and then asking the board to weigh in on whether it's lawful or not.
Yes.
But you'd agree that would be your choice as to what to base your allegation of a ethics complaint.
No, my allegation primarily is that they did basically what was conspicuously an improper act and held to it tenaciously for 3 years and hold to get to it today. It's still the law in Cobb County, what they did October 25th and 2022. That's pretty much beyond anybody's, there's no denying that. And the matter of charging their violation or their failure to follow the law is not the only element of my complaint.
Well, it's the only one that you allege in the complaint.
Well, I had an amendment, and I decided to hold it to see if you had any technical corrections that I would have to make.
Well, I mean, I understand we can only decide based on what you have filed. The complaint that you filed alleges,
Well, our only subject today is timeliness, not the merits of the underlying issues.
sure, but we can only look at what you have alleged in the complaint to determine whether it's within 6 months of the act alleged to be in violation. That's all we can look at.
Well, the official record is in the courts as to when, you know, I think I've cited all the correct dates for the court opinions. And, you know, if you want to conclude that my argument that you wouldn't take this on while it's being litigated, if you say, yes, you would take it on while it's being litigated, then that's going to be your call. I can't affect that. I think it'd be wrong, but I can't change it.
Well, I don't even think that that's before the board. It's my opinion. The only thing
Just
before
a
the
point of
board.
clarification. So
Yeah.
we're arguing about timeliness.
That's right.
And the question is that in the code of the Board of Ethics, it talks about an action that takes place, not a failure to act. And that I think is a fine part of this. And I think that, Mr. Savage, I think that's what you're arguing, correct? That you're arguing that their failure to act is then a violation of the code itself?
I'm not arguing that they failed. I'm just saying that they turned it on and it is now on. And every new day, you could look at it that way. You could say every day that we start out and they did business with this in the air, well, no matter which position they were in, every day that they operated when they were telling people that this is District 2 and this is District 4, every day that happened was a violation.
Right, but the action itself happened in October of '22.
Not the
Even though
actions
they
that
didn't
every
act
day
to
that-
repeal, right?
Every
So-
day that they answered the phone and said, this is District 2,
Right, but the
was a
action-
violation because there was a new action.
But the action itself that is being debated here is the action of the home rule, the acting of the home rule, which is October of '22. So the question of a failure to act, which is what you wanted them to do, actually to act upon it, not doing it necessarily, and that's, I think, at the question of the timeliness of this, that if it wasn't an action like that passing of the home rule, then a failure to act is not a violation of the code of conduct that would enact a timeliness clause, which would extend the tolling, correct? Carlos, is that really what the point of the code is then itself?
Yeah, I think so. And if the code were written to say that for every day or as long as the official fails to remedy the original act that was a violation, that tolls the deadline for filing of the complaint, then that would be, I think that would be in line with your argument, but that's not what the statute says. That's not what the
Well, my
code says.
contention is not that the code should say something. My contention is that they started And for 800 days, they have been in violation.
Any more questions? Thoughts?
I'm just trying to seek to understand here. I think I got it, but I just want to make sure. We're looking at Code of Ethics. And the Code of Ethics says 6 months. So Carlos, for the record, can you tell, or the date that you received the alleged complaint from Mr. Savage?
That was December of 2024. I think it was filed December the 19th,
Okay,
2024.
I had it, I just wanted to make sure, okay.
So, let's,
So I want to make sure I understand. These are not, what you're contending is this is not one violation, but this is a series of violations.
You can see it as a series of violations that went on every day, or you can see it as one violation that has operated continuously for about 3 years now. Now-
And so in October of 2022, the first violation, that could have kicked in an ethics investigation. That's when the clock started. Would you agree?
No, I do not agree. I don't believe you would have undertaken an ethics investigation while it was being litigated. And it was being litigated before that 6-month period was out.
Okay. I thought I heard you say started. I thought I heard you say, use the term started.
No, it did start
began.
undeniably started on October 25th, but it hasn't stopped.
Okay. Thanks for the clarification.
okay. Let me share my thoughts, unless anyone has any additional questions for Mr. Savage, and then I'd like to open it up for discussion, share your thoughts, and entertain any motions. So, it sounds to me like Mr. Savage believed that the enactment of the home rule map was improper, unlawful, when it was enacted in October of 2022. And that the reason for not filing a ethics complaint then was based on an assumption that the board would not rule in his favor. What I heard, not entertain the complaint. Not for untimeliness, because obviously it would be within 6 months, but on the merits, based on an assumption that the board wouldn't weigh in on the legality of the home rule map. The board can't engage in hypotheticals in what we would have decided had a complaint been filed, when all I know is that this complaint wasn't filed within 6 months of October of 2022. That we know. And we also know that the code has very specific language about when a complaint must be filed in order to be timely. And that is section 2-78, complaints. Subsection 2. A complaint must be filed within 6 months of the date the alleged violation is said to have occurred. The exception is in case of concealment or non-disclosure within 6 months of the date the alleged violation should have been discovered after due diligence. That, to me, that exception doesn't apply. As a threshold matter, prior to any other review of a complaint, so before any review of the merits of the complaint, the Board of Ethics shall dismiss a complaint which is untimely filed. if there were any other tolling provision, and by tolling provision, I mean something similar to this phrase, the exception of in case of a concealment or non-disclosure. If there were language to suggest that a continuing course of inaction to remedy a prior action tolls the time for which a complaint can be filed, maybe that saves Mr. Savage's complaint from being untimely. But if we're following a strict construction of the words and their meanings in the statute, on its face, there's no exception, there's no extension of deadlines, there's no tolling for this complaint filed in December of 2024 based on an act, the enactment of the home rule map in October of 2022.
May I add a comment?
Sure.
I was involved with litigation. I never asked any lawyers about whether I should file an ethics complaint, but I'm going to bet you they would say, don't do that while we're litigating this. Now, that's a little bit of conjecture on my part, but I think it's probably fair. And one other thing, I said before that I've been told in the past that the Ethics Board will not consider whether an official has failed to follow the law unless that's been adjudicated in court. Well, I would think adjudicated means to the end of adjudication. Also, that rule is not in the code either, but it's the rule.
What rule?
That you have to have a court order to say that something has been, that they fail to follow the law.
So, I mean, respectfully, this board's going to follow what's in the code, and whatever rule you're talking about isn't in the code, and so the board's not obligated to follow any such rule that you're talking about.
Well, it did last time I was here. It said you
I'm
can't
not
charge somebody
following.
with not following the law, and that can only be adjudicated in a court. Now, Mr. Rainey wasn't here. Somebody was standing in for him and made that a rule in that meeting.
You're talking about some deliberations that were done in a previous complaint.
Yes.
Okay. Didn't have anything to do with your complaint and the
Well,
home
I'm
rule
just
map.
sensitizing people to the idea that the code is, on the one hand, seems to be inviolate, and on the other hand, it seems to have a certain flexibility. I would hope somebody's making notes and make some of these changes in the code to clarify these things that are evidently too confusing to make them work.
So can I ask a point of clarification, Lynn? You know, to your point, that there's nothing in the code that speaks specifically to you're not allowed to file an ethics complaint if something is being litigated at the time. There's nothing in the code to that, is that correct?
There's nothing in the code that says that.
Right, so the question of conjecture or what should be versus what is in the code itself. And I agree with you, look, if there's a question of what the code of ethics should be or should be amended to say, that, I think that's a different question. But if there is no, if it's not mutually exclusive in that way, if you can file an ethics complaint while something's being adjudicated, then there is no conflict here. I mean, if that's my understanding, Lynn, you know, in the code itself.
I don't see anything in the code that prohibits the filing of a complaint while there is pending litigation.
Okay, thank you.
Anyone else have some thoughts?
Just going back to what we were saying about the complaint is their failure to act. And their failure to act, I understand what you're saying, but that's not a violation. So they didn't do something. There was no action. Them having no action is not a violation.
You know,
That's the way I
this
see it.
concept exists in common law. It exists in criminal courts. It exists in civil court, that there is a concept of ongoing violations, continuing violations. If somebody kidnaps a child, all the time they have that child in their custody is a continuing violation. They don't haul them in to finally arrest them and take them to court and charge them with one day's crime.
No, they do. When a crime is committed, there is a date alleged for when a crime
Well, I'm
is committed.
saying there are continuing violations, that's the point. That was the point I hope to make. There are continuing violations where something is made wrong and remains wrong.
I have a question, Mr. Savage. So just kind of, I want to stay on that line. So are you saying that if someone were to kidnap, let's just say keep a child for 30 days, that they would have 30 charges or one charge for
No,
kidnapping?
I'm saying that the courts regard that, and law enforcement regards that as a continuing crime.
Okay. And then the other question that I had is, you also mentioned that you had some experience with the board and not hearing a case while there was litigation. Sensing some uncertainty there, I'm just curious, when the court ruled in December of 2022 and then again in 2023, why did you not file your complaint at that time?
It never ended. The lower court ruled, the county immediately appealed, so it was still in play.
Thank you.
The litigation didn't end, and, you know, there are a lot of expressions about that, but the litigation didn't end just because Judge Harris said it was over. The county exercised their right to appeal, and they did so. And by the time that appeal was settled, a new suit had been opened by another person. It was the same underlying story, although their suit was against the Elections Board.
So your plan was to wait until everything was settled and then to file the complaint? That's why you waited until late last year? You wanted everything to be settled and all the courts to have finished?
I'm sorry,
Just going to the timeline, so I thought everything was done like last summer. We were talking about July, August, but I guess you were waiting to see if there were appeals. I'm just trying to
well, the county
understand.
The county did their part, allegedly, by enacting a resolution to adopt the maps, which did not repeal the resolution that started it all.
Okay, and you were waiting for to get through all the courts and all the appeals to file
I
the
am waiting for
complaint.
what the words of the Constitution state very clearly.
Okay.
And respectfully to Mr. Savage, it's hard for me to accept that, given that the complaint was filed in December of last year, and the Court of Appeals apparently just recently decided in February of this year to decline to hear Ms. Richardson's appeal of the decision. And so that was certainly filed within the pendency of litigation. I think the choice to file the complaint well after 6 months of the alleged act that, according to Mr. Savage, is in violation of the code, it ties the board's hands. And that's why the code provides for a mandate to dismiss an untimely complaint and not pass upon a review of the complaint in any other way, not on the merits, not for deficiencies. It is obligatory to dismiss the complaint. Today is to decide whether that decision that the board has already made should be reconsidered. And if anything, the opportunity to have this conversation with Mr. Savage only confirms the appropriateness of the board's decision to dismiss the complaint based on the clarity in the statute, clarity in the code, and the timing in which the complaint was filed. So that's my position. Does anyone have an opposing view? No. I'm going to call for a motion that we move that Mr. Savage's complaint from December 19th, 2024 against Chairwoman Cupid, Commissioner Richardson, Commissioner Sheffield be dismissed for being untimely filed. So I'll make that motion. Do I have a second?
Second.
Any discussion? Yeah, we need 1 second.
I'm
All
going
right.
to say it first.
Okay, so we've got a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Okay. Mr. Savage, I appreciate your presentation to the board, your willingness to have a conversation with us. I certainly don't fault you for your attentiveness. I think it's important for folks in the community to be involved in local government and keep a watchful eye. That is one of the hallmarks of democracy. But hopefully you can appreciate that as a diverse cross-section of this community, which certainly this board represents, and differing backgrounds. We're not all lawyers up here, but we're trying our best to follow the words on the page being the county code, and we have to adhere strictly to those words, and that's the decision that we've made. I think we have already arranged for our next board meeting. By statute, we're required to meet in May and in October. Obviously, we can meet in between those times if required to respond to any complaints. I'm not aware of any pending complaints. Is that correct, Mr. Rainey? When is our next board meeting?
So our next board meeting is May 28th at 3:30.
May 28th at 3:30.
Correct.
Excellent. So there being no further business, I'd like to entertain a motion to adjourn.
Second.
Mr. Yonker and a second from Ms. Pundle. All right, all in favor say aye. Aye. And hearing none opposed, we are adjourned. Thank you.